It gives me a great pleasure to interact with all of you on behalf of ICSI IIP. We are part of the regulatory framework of IBPI, and all the resolution professionals who are working in this field have contributed a lot on the purpose of fulfilling the objectives of IBC. When the IBC was set up, since then, more than 5,258 total cases have been processed under the IBC till March 2022. And out of that, 3,406 cases have been closed. Total of 1,609 cases have gone under liquidation, and 480 cases have gone for resolution plan. The total amount of debt which has been released through the IBC process is more than rupees 6.85 billion rupees, and creditors have got their money to the tune of rupees 2.25 trillion. That's a very big achievement, but there are still several issues which cannot be fulfilled without the awareness and joint effort of all the regulator or IBPI or various parts of the companies which are regulating the resolution professionals or resolution professionals themselves coming forward to fulfill this objective. Some of the issues that are still in pipeline and consideration of IBPI are very important and have been derived through the experience over the last several years in operation of IBC under the guidance of IBPI. There are issues with regard to pre-packs for MSME, though it has been allowed. Other corporate sectors also want to undergo for debt restructuring. That is an important area where more work is required. Then various companies under the resolution plan require certain expertise in the field where they are operating. Though ICSI and other professionals are well versed with the corporate working and running of the companies, some domain knowledge is also required. So there is a document by the IBPI where it is under discussion that should there be an corporate entity working as a resolution professional, which can have the talent of some of the people who are having the domain knowledge. Then there is also an issue of prioritizing in the committee of creditors about functional creditors, operational creditors, what is their priority, and can there be new categories of creditors in the committee of creditors as has been included in the past about the home buyers, etc. And several discussions are also taking place whether the NCLT, which is an important part of the whole regulatory mechanism, how much infrastructure does it need? More strengthening of that infrastructure has been there as a requirement where these are issues are being discussed. But one thing is very clear that over the past period, IBC itself has gained ground and is well entrenched in the resolution process. It is also giving a respective exit route from for the corporates who are under the risk of businesses and who are facing risk in their business entities because of various reasons. And IBPI is continuously monitoring and improving the whole process. Some of the important issues that I would like to highlight through this video recording to all our professional colleagues is that These important judgments are part of the IBBI awareness campaign, and ICSI IIP has also been undertaking several awareness programs, training programs, online information dissemination. All these issues are very important, and if all the members who are working in this field get abreast to some of these amendments, it will benefit the whole ecosystem. And I would request that ICSI IIP has always been in an outreach approach for the improvement and development of the whole ecosystem. So some of the issues just I would like to underline is that the most important element in the IBC resolution which has come to the forefront is maintaining a timeline. The IBBI and the other regulator, valuer or resolution professionals or the other companies like our company, they have been working to maintain the timeline, whether it is through the disciplinary committees or awareness creation, etc. So maintaining and promoting a fixed timeline is an important part, which is in the objective of the whole ecosystem and the government. Even improving realization of the assets under liquidation or under resolution is an important part of the process. There is issues with regard to some amendments into the fees of IPs. Balancing stakeholders' right is also an element where a lot of working is being done by the whole ecosystem, so that the rights of the, whether it is financial creditors, operational creditors, or whether it is government recovery, etc. The stakeholders' right is an important area of concern. Vendors are also included, employees are also stakeholders, shareholders valuation is also the important area. And the grievance redressal, handling of the grievance redressal is an area where we are working in tandem with the IBBI. Even with regard to disciplinary committee, the IBBI has strengthened the whole process. It is also taken over the disciplinary mechanism in the hands of the IBBI nominees. That's also an important issue where some new amendments are required. I think this kind of outreach by the ICSI IIP to go to the members in important part of the whole process of strengthening IBC. I would request all the members to continuously engage with the ICSI IIP so that certain issues with regard to development of the whole ecosystem is continuously taken up. Certain court cases are also being regularly updated in our website. You can go to the website, read about those court cases, important judgments, what are taking place, new development that are taking place, the government regulations or government clarification, IBBI clarification that are coming forward. They are also updated, and IBBI website is also very exemplary. They give all the information in this period of current financial ecosystem. Information is power. Knowledge is power. We should all work towards gaining more and more knowledge. Even the disciplinary proceeding and the decisions of the ICSI IIP is also very important for members so that they can abstain from certain issues which can cause disciplinary actions. That is also important. On the basis, on the requirement of the compliances also, we take up regular cases, training, seminars, etc. Because compliance is very important. Without compliance in the current scenario, no professional can do justice to his duties or responsibilities, and there is huge accountability with regard to various aspects of compliance requirement, regulations, etc. Ultimately, we are all part of the resolution mechanism. At global level, various new initiatives or new notification, judgment, amendments are coming. These are being slowly and steadily incorporated into our domestic laws. And various banks are also actively participating so that their debt resolution takes place. And ultimately, the final objective of whole process is that we move towards running of the company. So as a company as a going concern is important. It is not a liquidation process or debt realization process that is important, but company working as a resolution, companies working as a going concern, that's important. So I would just underline some of the points that I think are important for your consideration is IPs shall give his relationship disclosure at every communication. They should maintain an arm's length with other professionals whom they employ for their work in the resolution process. They also need to look back on the period of avoidable transactions that have to be listed into the resolution process. Sometimes some resolution plan are received post the process has been completed, and unsolicited resolution plans also come to the notice of the resolution professionals how to deal with them. That's an important issue, and ultimately provide the conduct of the members of the COC. There are guidelines how the COC meetings have to be conducted, how the minutes have to be kept, who can be represented into the COC, what issues they can have to be taken, what fees have to be paid to different professionals. All these, their approval from the COCs are important for the consideration of members. We have also to look into some of the court cases. I would just like to mention some of the important court cases that are very important for all of you. In the case of K. Paramasivam and versus the Karur Vyas Bank, the court has upheld that the liability of the guarantor is coextensive with that of the principal borrower. That's an important decision because at the time, some of the guarantors, they think that their liability is not coexistent with the principal borrowers. Then there is a case of sale tax officer versus Rainbow Paper Limited, where it says that the government dues cannot be overlooked and secured or functional creditors cannot prioritize their own dues over the government dues. That also is important decision. Then Sudarshan Bhatt, liquidator of ABG Shipyard versus Central Bank of Board of Indirect Taxes, where it says that IBC Act will prevail over the Custom Act and it gets prioritized over the Custom Act. Then there is a judgment of Vidarbha Industries Power Limited versus Axis Bank Limited, where Supreme Court held that it is not mandatory for the adjudicating authority to admit an application to initiate corporate insolvency resolution process, even if a debt existed and corporate debt is in corporate debtor is in default. So every case which comes to the Supreme Court will not go to the IBC process, and that's very important because slowly and at times people think that IBC is only for debt recovery. That's not the objective of the IBC. In the case of Valal RCK versus Messrs. Shiva Industries and Holding Limited. The court has upheld the adjudicating authority or the appellate authority cannot sit in an appeal over the commercial wisdom of the COC. If the COC, 90% of the COC member think that it is in the interest of the company and in the interest of the stakeholder to permit settlement and withdraw CIRP. So the appellate authority cannot reject that. That's an important decision. In the case of Indian Overseas Bank versus Messrs. RAM Infrastructure Limited, the Honorable Supreme Court held that the proceeding under the SARFAESI Act cannot be continued when the CIRP proceeding is initiated. So earlier cases have do not have the precedence over once the CIRP proceedings are started. So these are some of the important court cases. We have to get into the detail, read those objectives and continuously engage with the ICSI IIP so that professional development take place, and with IBBI guidance, we all work in an ecosystem where resolution of the corporate debts takes place in a smooth and healthy environment. So I request all of you to continuously be in touch, engage with the ICSI, IIP, create knowledge bank of your own, and get awareness about the new amendments, etc. And wish you all a very successful and fruitful career as a resolution professional. Thank you very much, and my good wishes to all of you. Thank you.